is the order in which people talk at this hearing?
The person that has filed the paper gets to talk first because that's their request. So if it's a petitioner, petitioner gets to talk first. If it's the respondent, respondent gets to talk first, depending who has filed for it, which is interesting because at the time of trial, the person who has filed the petition moves first. So, but in this case, whoever files first, even if you are the respondent, but you have filed your RFO, you're the person that would talk first because that's your request.
Okay, so say I talk first, then does the other side get to talk or present witnesses?
Of course. The judge, and it's very interesting because when I sit as pro tem, I learn to be patient. A lot of attorneys talk over each other, and then when you sit on the bench, it's very annoying. So the judge wants to hear from both sides. So the person who has filed the RFO will come up with, Your Honor, this is what has happened. This is what my client has done. And this is why my client is requesting what he's requesting. And if there's anything that needs to be added to, gets added to at the time. Then the other side gets to respond and by saying, well, they want this because of that, and that is not right. They make their argument. But again, being the person that filed gets the second bite. I get to reply.
Okay. So you get to argue again.
I get to argue again. And at times, this rule is not quite obeyed because it becomes a ping pong. If the judge allows, then the other side tells, his side is right.
And does the judge make a decision right then and there?
I've seen judges make a decision right there and then. I've seen judges that they take it under submission. Okay.
What does that mean?
I will explain it. If the case is very simple and the judge sees both sides being calm and understanding or reasoning, the judge will make the ruling on the bench. There are times that one side is very angry or it's up to the judge. The judge will say, I will make the decision later after this hearing, and I will send you my ruling. That is what's called under submission. And that's actually something that's taught in judging school. The judges' school saying, if you see someone that could create some discomfort for the court, do not rule on the bench. Take it under submission, let the parties go home, and then let them receive it in the mail. And that's what's called taking under submission.
Now, does the judge have to issue a decision that is written, or is it just oral?
What courts do, the person that sits there typeset, and then there is a clerk behind that person that writes down what's going on. That writing down what's going on, it's called minute order of the court. So the judge will not handwrite it. Well, there are times they do. If you prepare the order for them to sign it, they will write it in the form that you prepare them. Let me go back and explain how it is. When requests for orders are filed, there are forms you can file, which is in the blank forms that relates to the issue that you want the rulings on. There are times those forms get filed. I mean, it is best to file those forms with the RFO for the judge to actually initial and write his decision on that form, which becomes the order after hearing. However, There are times the person that takes notes of the judge's orders, the minute order, that sometimes minute order of the court becomes the order of the court, so nobody has to prepare the order. Or there are times the judge says, petitioner, you prepare the order if it's not included. So it gets prepared, it gets sent to the other side for approval and their signature. And if it doesn't get returned within certain time, then you can file it with the court for the judge's signature. So everything the judge says, one way or the other, gets written, either in the transcript, in the minute order, or order of the court, or order after hearing.
Now, what is this process that I've heard that you can make the judge write a written opinion?
Statement of decision?
Right.
The statement of decision. Depending how long your case is, the hearing is, you can ask the court, and I do that in my petitions. If the case is complicated and I'm about to file a petition, in my petition, I request for statement of decision, petition for dissolution. Sometimes you want to hear why the judge made the decision that he did or she did. You want the logic behind it. What is it that the court heard that gave such orders? That's called statement of a decision, which means, judge, explain yourself how you arrived on the decision that you've made. You can request it, and the judge will put his decision in detailed writing and send it to you, why he made the decision that he did.
Are there any procedural requirements to ask the judge to do a statement of decision? I mean, could you just at the hearing, at the end of your argument, say, hey, I'd like a statement of decision?
No, you need to file requesting the statement of decision.
Before the hearing?
Before the hearing.
How do you think judges react to that?
You know, nobody likes to do it, but they do it.
Do you think it gives you an advantage or a disadvantage?
It really, here's my personal opinion.
Mhm.
If I were the judge sitting there and I'm being asked, okay, you make that decision, I want to know your reasoning, not because I think your reasoning is sound, because I want to know, because I want to hear it. I don't know how I feel about it. I don't know if I like somebody questioning my decision. However, there are times, like, as I said, not all the petitions I filed requested, but let's say spousal support, okay? Let's say I have a client comes to me and says, look, my spouse earns his or her income in cash. We have an extravagant lifestyle, but he shows $1,000 a month income. Now, if I am to file for spousal support, and if it is based on income and expense declaration, I have $1,000 income per month to show, right? But if I'm going there and arguing that the expenses, the lifestyle they had is $20,000 a month, but the income is $1,000 a month, I would want to know how the judge comes up with the amount of support that he has ordered. I want to know if the judge considered the $1,000 a month car payment. I want to know if the judge considered the extravagant trips or whatever. On those little issues, I want to make sure that the judge has heard me. Right.